Greetings and welcome back. Today we turn to question 2, December 2022. The subject is meetings, compliance and administration. Question 2A reads, identify 5 parties that may petition a court to liquidate a company. 5 marks. 5 parties that may petition a court to liquidate a company. The first party, creditors. Number 2, shareholders. Number 3, directors. Number 4, registrar of companies. Then 5, contributories. Those are 5 parties that may petition a court to liquidate a company. I repeat, number 1, creditors. Number 2, shareholders. Number 3, directors. Number 4, registrar of companies. Then 5, contributories. That is the solution to question 2A. Question 2A. Parties that may petition the court to liquidate a company. 1, creditors. 2, shareholders. 3, I mentioned registrar of companies, directors. 4, registrar of companies. 5, contributories. These are the 5 parties that can petition the court to liquidate a company. Creditors, candidates who are owed outstanding debts by the company may petition the court for liquidation if attempts to recover the debts have been unsuccessful. Here they seek to have the company's assets liquidated to satisfy their outstanding debts. Creditors. Then we have shareholders. Shareholders may petition the court for liquidation if they believe that the company's affairs are being conducted in a manner prejudicial to their interests. And that could be due to, say, mismanagement. That could be due to fraud or other actions that harm the shareholders' investments. Directors or officers may also petition the court to liquidate a company. The registrar, in certain cases, the directors or officers of the company may themselves initiate the petition for liquidation if they believe that the company is insolvent and there is no reasonable prospects of being able to bring it back. All right? Directors. If the directors feel that the company is insolvent, then they can petition the court to liquidate the company. Registrar of companies or the relevant regulatory authority overseeing companies' registrations may petition the court for liquidation if the company has failed to comply with legal requirements, such as filing annual returns, filing financial statements, or other regulatory obligations. Then lastly, we have contributories. Contributories are individuals or entities who are liable to contribute to the assets, who are liable to do what? To contribute to the assets of the company. Contributories. And these individuals are liable to contribute to the assets of the company in the event of winding up. They are individuals who are liable, I repeat, to contribute to the assets of the company upon its winding up. So they may petition the court for liquidation if they believe that the company is unable to pay its debts and they want the liquidation process to commence. So these are 5 parties that may petition the court to liquidate a company: creditors, shareholders, directors, registrar of companies, contributories. 5 marks. That is part A.